Hi guys, welcome to Probate Matters. My name is Jenny Dinker. I'm our client onboarding manager with Guardian Probate Law Group and Georgia Probate Law Group.
And I'm Erik Broel. I'm the founder and CEO of Georgia Probate Law Group and Guardian Probate Law Group.
Before we jump into our episode today, we have a little disclaimer here for you that I am not an attorney. I cannot give legal advice. Erik is an attorney, but any information you hear here today is just general information. For your specific situation, please reach out to us and we'd love to speak to you about that. Now, Erik, we went over will contest in the last episode.
Yeah.
We went deep into that. There was a lot to cover about that. But there's other dispute situations that are not tied directly to a will contest when it comes to estate administration. So there's a lot of other topics we can cover with things like that. So I want to go over a little bit today about how step-parents fall into estate situations.
Okay.
And how that works. Because especially when there's not a will in Georgia, and let's say that a father passes away, he has remarried, he has 2 kids of his own, but she has 2 kids that are not his kids. What happens in those type of situations?
That's a great question. That's actually the scenario why our firm exists. Because I had that, as you know, I had that situation in my family, right? My uncle passed away. He had 2 kids from prior relationship. My aunt survived him. She had kids from prior relationship. And then that whole estate situation was just awful. It was awful watching the house come up for sale, watching her pushed around in a wheelchair, the little price tags on everything in her home.
Yeah.
And so it can get messy and it can get rough. We have to talk about why that is. And the reason is because when there is not a will, who is entitled to inherit the property, and really we're talking about property, who's entitled to inherit is based upon state law. And so here, where you have a step parent, they're the spouse of the deceased, right? And they have kids. The deceased also had kids. So the deceased's kids under state law, at least under Georgia law, are going to be entitled to inherit. And their spouse, step or otherwise, is going to be entitled to inherit. Now that leaves out the children of the surviving spouse. Why? Because they're not blood relatives. They're not related to our deceased person. The only way for them to inherit would be if there was a will that said they're supposed to receive something, or if there was a formal adoption that had taken place. So if there was a formal adoption, that works because then legally, they are legally the children of the deceased, right? Even though they may not be blood related. And we see that from time to time.
Yeah.
So these type of situations can absolutely be fraught with conflict. What we see in the office from an emotional standpoint is that the person who passed away, especially when these situations blow up, is often the glue that was holding everything together.
Yeah.
And you may think everything is great, right? Or it may be that, you know, his kids never liked stepmom and she never liked them, but they all kind of made it work for the sake of dad.
Yeah.
And then dad passes away. And now what? Right? Now we've got oftentimes you have stepmom feeling like I was married to him. You know, I am the spouse.
Yeah.
I should inherit. I should get whatever I should get. And then you have the kids saying, oh, you've only been with him for 10 years or 5 years or 2 years or whatever. And, you know, you must have conned him into marrying you. Yeah, you get all those kind of stories, right? Where each party has their own story, their own narrative going on in their head. And that narrative is what's driving their behavior. But at the end of the day, you've got 2 parties that are both after the same stuff. And it may be purely emotional, it may be purely sentimental things they're after, or it could be, you know, their dislike for the other party or their own personal sense of I should get this, I feel like this is right or fair or whatnot is driving them into conflict with the other person.
Yeah. And what a lot of people don't know, it seems like, is that if there's not a will in Georgia, and the dad passes away and you have stepmom and then the dad's children, stepmom's going to get some of that estate if there are probate assets. Is that right? I mean, there's no way to disinherit stepmom from the estate.
No, not without a will.
Yeah.
Not without a will. And so let's talk about this. let's talk about this. If there is no will, in your scenario, it's a third, a third, a third, right? The spouse is going to get a third, and you have 2 kids, and they're going to split the 2/3 equally. So a third, a third, a third of all the property.
Yeah.
Now, what happens if the house was totally, completely in Dad's name, but Mom, stepmom lives there? Well, I mean, it's a third, a third, a third.
Yeah.
So now that house potentially has to be sold.
Which is what happened in your
That's what happened in my situation. So my uncle, everything was set up kind of traditionally. He was a traditional guy, kind of that generation. And the house was solely in his name. Almost everything was solely in his name. And so when his kids, and that state's laws in this respect are similar to Georgia. It didn't happen in Georgia, but when his kids said, well, we want our part, they were able to force everything, including the house, to an estate sale to get their part. Now, I mentioned, in the last episode, we talked about this at length. The family, fortunately, was able to come together as a group and buy the house back from the estate. One of the key parts of that is the family was able to buy it at a discount. If just for simple math, if we say the house was worth $150,000 and your surviving spouse, my aunt in this case, her share was worth a third, well, anybody else coming off the street would have to buy the house for $150,000. She could buy it for $100,000. Because $50,000 of that was already hers.
Yeah.
And so that's how the family was able to do it, by buying it at a discount with her share, and they just, put the money together and made it happen. And fortunately, there was enough of them and they were able to make that work, but that's not true for every family. And so there are situations, and it's gut-wrenching. It's heart-wrenching when you're talking to a client, and especially a surviving spouse that's lived in this house for a long time. I'm not talking about the wedding that happened 6 months ago or whatever. You've got long relationships, 10 years, 15 years, 20 years, where these are committed long-term marriages. And but the assets weren't set up in the right way, and now she's in a rough spot.
Yeah.
And, if there are other assets, if there's investment accounts or savings or, just kind of cash assets, cash, stock, securities, that kind of thing, where maybe we can offset, that can help, where she can keep the house and, the kids can get their part out of some of these other assets, but that's not even always the case.
Always, yeah.
And so, and I'm not even talking about debts, right? Creditors and that kind of thing. I'm skipping over that. I'm assuming there's no creditors in this example because that adds a whole other layer of complication on top of this. So that's the bad side.
Yeah.
What's the positive side? The positive side is this can get fixed if either the assets are set up in the right way or if there's a will. So I want to talk about that a little bit. We don't do any of that work.
Yeah.
We don't write wills, and we don't really move around real estate. We do in the context of an estate. We'll move around real estate, but we're not out there trying to rewrite everybody's deed. That's just not our thing. But I think it is important. It's important for folks to understand some ways that they could set things up that will have a very large impact in a probate situation, particularly in a blended family. One of those, let's talk about deeds. So the house deed. If it's solely in one person's name, husband or wife, that's going to cause problems. Unless what you want is for it to be split up between your spouse and however many kids you have. Well, then there's no problem if that's what you want.
Yeah.
But if that's not what you want, just going and rewriting the deed to where we put both parties' names on it, that fixes it. Now, there's 2 ways to do that. There's joint tenants with rights of survivorship, and there's tenants in common. A lot of fancy legal words, but joint tenants means when one of them dies, the house becomes automatically the property of the other one. Tenants in common means that when one of them dies, the one half owned by the surviving spouse is theirs completely, and the one half owned by the deceased spouse does go into the estate process. That can still cause the forced sale of a house. I've seen it. We've been a part of it. We have unfortunately been on the forcing end of that and the receiving end of that.
Yeah.
And so, if the relationship is good and we're talking about a long-term committed marriage relationship, joint tenants is really a very, very useful tool for that. The other way you can deal with it is by having a will. And there's just a ton of confusion out there and a lot of confusing information about what a will does and what a will doesn't do.
Yeah.
I've heard things like, well, if you have a will, you don't have to go through probate. I've also heard things like, well, a will doesn't really do anything. There's no reason to have it. A will does, in the simplest possible terms I can make it. And I'm a probate guy. I'm not an estate planner. A will is going to do two things for you. It's going to let you decide who gets your things when you pass away instead of state law. And it's going to let you decide who is going to be responsible for managing the estate process. There are a bunch more things I can go into that a will can do. But those two things right there, every will, it's going to get that done for you. And in our scenario with step kids or step parents or whatnot, a will also fixes our problem. Because if there's a will, then we could say, I leave everything to my spouse. And if my spouse is no longer here, I leave it to my kids. Or maybe I leave it to all of the kids, my kids and my spouse's kids, right?
Yeah.
To me are step kids, but to my spouse, they're her kids and mine are the step kids, right? And maybe we agree as a couple to do that.
Yeah.
We're each going to make wills that mirror each other in that respect. But a will also solves it because then, if I pass away, even if the house is solely in my name, my will says it's going to go to my spouse. So now, in terms of my kids coming and trying to mess something up for my spouse because they don't like her that much, their stepmom, it kind of cuts out some of that.
That makes sense.
And then with a will, it doesn't even have to be that simple. It can be more complicated. I could say, you know what, I'm going to give each of my kids $10,000 and I'm going to give the rest to my spouse, right? I'm just picking numbers out of the air. It could be anything you want it to be, but it allows that to happen. And I think I've seen it just too many times that in a blended family situation, will's super important. It just, it settles things.
Yeah.
Now, and this is a question for the estate planners and figuring this out, but if I die first, even if we have those mirrored wills, it says everything to my spouse and then everything to the four of the kids. I mean, if I die first, my spouse can change your will even after I'm dead.
I was about to ask you that. Yeah.
Yeah. So you've got those kind of situations. There's other vehicles like trusts and whatnot that can attempt to deal with that.
Yeah.
I don't personally like trusts very much. We find in the office they cause more harm than good generally because they're just not funded properly. Yeah. The steps are not taken. You got a nice document somebody paid a bunch of money for, but then it doesn't own anything and you got problems.
Yeah.
But a well-done trust that's properly funded in this situation, it could help solve that.
Okay. Yeah, that's what I was going to ask you about the will language because we get this a lot where maybe the father did have a will, let's say, in that same situation we just talked about. The father did have the will and said everything is left to my spouse, and then if my spouse is deceased, it will go to my children. And the children have had conversations, and the dad said, hey, don't worry. When she passes, the will says everything goes to you. But it's not exactly like that, right? It would actually go to the spouse. In most, if that was the language very straightforward, it would just go to the spouse. Then that's where it stops because the spouse is alive when he passes.
Yeah. Yeah, you're exactly right in that. And so now what happens when the spouse passes away? Well, we go to the spouse's will. If the spouse's will is the same will that was created with the husband that had died, great. Yeah. But if she changes her will, let's say she gets remarried, right? Changes her will and now cuts out his kids. There's not a lot we can do about that. Yeah. And we've had it happen where you've got like family heirloom type property or maybe a piece of real estate that's been in the family for a long time. And it passes in that way. It's in his side of the family. He dies. It winds up over here with her. It's supposed to go to the kids, but then she changes her will, and the kids are really mad about this. And now that piece of property is like going to go over to her side of the family or go to her new spouse or something. And it's at that point, there's not a ton you can do about it, which is why I think the planning is so important. So how could we have fixed this? The simplest way I can think of is if we had, when in his will, if he owned this property, if we had a trust inside of the will, what we call a testamentary trust. Testament, and the will says, I leave this property to the trustee of my testamentary trust.
Okay.
Now the trust owns the property. We can have in the trust document, which is in the will, something that says my wife at the time of my death can live there for as long as she wants to live there. And then when she passes away, it goes to my kids because we're going to keep it in the family. We never in that situation ever actually transferred it to her. We put it in a trust, and the trust had instructions on what to do. The trustee was supposed to carry those out. But we gave her the use of it for the rest of her life, and then we moved it back over to the kids to keep it in the family. That's a simple example of how we could solve that situation with step-parents.
I like that a lot because I think that not a lot of people know that they could set that up that way with a testamentary trust inside of the will. And they just think that the standard will format is going to be, when I say standard, well, I just mean that it says, I bequeath this to my spouse and then my kids after that. They think that's going to cover all bases. But it sounds like something like that would cover it a lot more in the long run.
It does. And the advantage of a testamentary trust is it's not a living trust. Living trusts are the ones we tend to have problems with because you have a living trust that's already supposed to own this property.
Okay.
And that just, people forget to put property in it. People, when things change, they don't update it. And so, but if it's a testamentary trust inside of a will, it doesn't even come into existence until the will is probated.
Yeah.
So from an administrative standpoint, it's much easier during the person's life because they don't have to do anything differently.
Yeah, exactly. I like that. Well, and you were saying that going back to the no will situation. So I know we talked about will for a minute. I want to go back to the no will situation. So in the situation where we talked about no will, spouse passes away, you have, let's say, stepmom and then his two children that are not her children. You said a third, a third, a third.
Yeah.
But there is something in Georgia called year support that can kind of mess with that a little bit.
Yeah.
So can you tell our listeners what year support is and why it is so important in a situation like that?
Yeah, absolutely. I love this topic. When I talk about my story and my aunt, and how there were things that could have been done to make her situation different.
Yeah.
This is one of those things. We call it spousal support. Every state has their version of spousal support. In Georgia, we call ours year support. Tennessee calls theirs something else. And so in Georgia, the way year support works is it's available to a surviving spouse or minor kids of the deceased, and it allows them to take a portion of the estate or be awarded a portion of the estate off the top. And the neat thing about off the top, we've talked about creditors before, right? So when you have an estate and you have estate property, well, first, all your creditors in all their various categories have to get paid. And then after they're all paid, then the family gets money, whether that's through a will or in a no-will situation. They're at the bottom. What year support does is it takes our surviving spouse or minor kids and it allows them to get property off the top before even creditors get paid. And so it's super powerful. It's a super powerful version of spousal support that we have.
Okay.
And so in this situation, where we have a surviving spouse and we have two children, assuming those children are adults. If they're minors, this doesn't work the same way. But assuming they're adults, then that allows us to file this year support petition on behalf of the surviving spouse and gives that surviving spouse a lot of advantages in the case. Because now our surviving spouse is going to get whatever they get out of year support, which we'll talk about in more detail. Then creditors get paid. Then the remainder of the estate is split a third, a third, a third. Our surviving spouse still gets her one-third portion of what's left at the end. So that, as you can imagine, can really change the dynamic and change the negotiations when you're talking with stepchildren who are coming in to try to take whatever they can take. So in my aunt's situation, this would have been a game changer.
Yeah.
Instead of the kids coming in and saying, we'd like to get ours, we want, sell the house, put stickers on everything. She would have been able to say, or her attorney would have been able to say, no, wait a second, I'm entitled to this. And so I'm filing this. I'm going to get this amount off the top of value of the property. and then we're going to split what's left, it changes everything.
And they may have even looked at that situation and said, she's the surviving spouse. She needs a place to live. You have no
Exactly.
right to it at all. They may have made that
Exactly.
decision at that point.
Exactly. I can tell you in Georgia, so the way ours works is really neat. You get whatever you ask for unless someone objects. So you can imagine the games we play with creditors with that kind of language in the statute, because creditors do not always object. So there's been plenty of times where our team has successfully taken the entire estate through year support, and we've been able to avoid paying creditor claims.
Yeah.
That's fantastic. Huge win for the family. Way more than pays for our fees, right? Another way it works is, let's say someone objects. So we file it. Now, the stepkids, they always object,
Yeah.
right? They're not too happy about it. Then the statute goes on and it says, but if someone objects, there's a formula. And what we're looking for is the surviving spouse is entitled to 1 year of the standard of living that was lost as a result of the death. That's where the name comes from, the name years support. It's because the measurement we're looking at is 1 year of the standard of living. Now, what does that mean? That's a lot of words, but what does it actually mean? Well, it says we look at other sources of income and assets the surviving spouse has, and we look at what was lost. So in a situation where you have a surviving spouse that was totally dependent upon the spouse that passed
Financially
away.
dependent.
Financially,
Yeah.
yeah, that's what I mean. Let's say he was the one working, she was not working. Well, we would look at the income disparity, and we would look at, how much was he bringing to the household? And now, where does this household stand? And we can do the math. If he was making $100,000 a year and she was making zero, we've lost $100,000 a year.
Yeah.
So our starting point is going to be, okay, well, she should get about $100,000 worth of property off the top. Now, the kids can come in and argue, yeah, but he had an employer life insurance policy for $20,000, so we need to take that off. Now we're down to $80,000, right? Oh, well, look, she has her own 401k, IRA, whatever, from when she was working. There's savings here. Now we're going back and forth and we're arguing about this formula. The formula is not clear cut. I wish it was something we could just plug in Excel and that would give us a number. It's not.
Yeah.
To your point, it's also really hard, I think, to just tell a surviving spouse, no, we're going to sell your house, especially when there's a year support petition.
Yeah.
I think you've got that empathy for a surviving spouse that the courts are able to recognize,
Yeah.
and the hardship that's being placed on that surviving spouse through the year support process. Whereas the typical estate process, that's a third, there's none of that. It is what it is. It is a formula. We're splitting it up. The year support process is more flexible. It's more flexible and amenable to those kind of arguments. Now, from a procedural standpoint, you do both, right? You have to run the estate process. You also run the year support process, and typically you run them simultaneously. And if there's an objection in year support, just like we talked about before, you can you go into discovery and you go into the civil dispute type process.
Yeah. And a big part of this, or something that's really important, I think, for everyone to know, is the amount of time they have to file that, because it's only 2 years.
It is only 2
from
years.
the time of the passing, right?
Yeah. Yeah, and that's, I'm glad you brought that up. That's super important. It is, and it functions like a statute of limitations. And what that means is there's nothing anybody can do, no court, no judge, nothing. If you cross 2 years from the date of death, the right to year support is extinguished under the law. So you're done. There's nothing you can do.
Yeah. So that's an important deadline.
It's very important. There's a couple of other ones I think that are important. For example, the spouse cannot remarry. Right? If the spouse
know
gets
that.
remarried,
Oh, wow.
then their right to year support is also extinguished.
Okay.
And so that one's interesting because a lot of statute of limitations type stuff is filing dependent. I'm getting very technical, but meaning that the year support doesn't have to be finished in 2 years, but you have to get it filed within 2 years. So if I go 1 year and 364 days and then I file my petition with the clerk, I'm good.
Yeah.
I got it in on time.
Yeah.
However, the marriage thing, you could be in the middle of the years support petition, arguing things out, getting ready to go to a hearing, but it's not been completed.
Yeah.
If the spouse gets remarried, the other side can get the whole thing dismissed.
Wow. Huh.
Yeah.
That's
because it's
interesting.
seen as, well, you don't need
Now you have that income.
Yeah, you don't need
at
the
that
support
point.
anymore, right?
Yeah.
You've obviously moved on.
Yeah, exactly.
Right? And so, but yeah, that 2-year statute of limitations is super important.
Okay. And you touched on earlier, well, if there were minor children involved in this, then that changes it. Why does that change it versus adult children?
Ooh, that's great. That's great. So remember the initial requirement I gave. Mm-hmm. It's available to surviving spouses and minor kids. Once a child turns 18, they're no longer eligible for it. But if they're under 18, they are equally eligible with the spouse. Mm-hmm. So what that means is you can't leave them out. The kids can't leave the spouse out, and the spouse can't leave the kids out. And so in this, when you get into a step situation, this can be a little bit challenging.
Yeah.
So both parties have a right to petition. Mm-hmm. And now we're back to our split thing.
Yeah.
Is it going to be an absolute even split down the middle? Probably-ish. I mean, again, remember, your support has more flexibility. The court has more flexibility to look at the facts and circumstances in the situation. And so, but the kids will inherit. They will get something in your support. So when I talked about how your support goes to the top and we take it off of the top,
yeah,
those kids are now included. So our strategy of taking more off the top for a surviving spouse doesn't work as well with minor kids. Mm-hmm. If there's a minor child and a child that's over 18, it really disadvantages that child over 18 because the spouse and the minor child are going to participate in your support. Then we pay creditors. And then there's a 1/3, 1/3, 1/3 split at the bottom, right? So that minor child and the spouse are going to wind up with considerably more probably than the child that's
the
over
adult
18.
child.
Yeah. So, and talking about deadlines, because that was a great question you asked, with the minor children, once they turn 18, they're ineligible. Mm-hmm. Now, what's interesting with your support with them is you just got to get it filed before they turn 18.
Got it.
Right. So if they're 18 after it's filed, then they remain eligible unless it's dismissed. But it's a filing deadline for them.
So essentially with minor children, there are two potential deadlines because they have to be under 18, so they can't turn 18 years old, and it has to be within the 2 years from the time that the person passed away. It can't be after that, so they can't wait 3 years and still not be 18. It has to, basically both of those things have to be true.
Yes, that's right. So easy example is, let's say the child is 17 years old when their parent passes away. We've got until their 18th birthday.
Got it.
If their 18th birthday is a month away, we have a month. If their 18th birthday is a year away, we've got a year. It's whichever happens first, either 2 years from date of death or the minor turns 18.
Got it.
If the minor is 10, then we have 2 years, the normal statute of limitations.
Okay. Yeah. So really to summarize your support for our listeners is, from what you're saying, it's a creditor's claim, essentially, for a surviving spouse or a minor child that can be filed against the estate to request for more than what they're entitled to from the estate. Is that correct, or would that be incorrect?
I think so. I mean, it's a creditor's claim, and it's valued based upon what was lost, the standard of living lost as a result of the death. I guess I can go with that. They will wind up probably getting more than they otherwise would, either because we get more from creditors or because they're able to get more than they would under a typical split without a will. Mm-hmm.
Which makes sense, because it seems like what the courts are looking at is saying that either if it's a minor child or a surviving spouse, you no longer have that financial resource anymore to help with your livelihood. So because of that, we're going to give you X amount to assist with that in the future, basically.
Yeah, and if you look at the history of it, right, this law is, I think it's over 100 years old at this point. So if we go back in time, you had society at that time was mostly the male was the working breadwinner of the household, and the female stayed home and raised the kids. Yeah. So if we look at it through that lens, the reason and how it works starts to make more sense.
Yeah.
Now, it's available to both sexes, right, at this point in time.
Exactly.
At one point, I believe it was only available to wives.
Oh, wow.
Yeah, but it's available to both genders. It doesn't really matter. But just looking at the history of how it came to be, it makes sense about this. Okay, oh, well, the man of the house passed away. The breadwinner passed away. We don't want to throw the wife and kids out on the street.
Makes sense.
We're going to make sure they get a year, right, to figure everything out. We're not going to let the creditors take everything. We're at least going to give them a year's worth of the income they're used to.
Yeah.
That gives them time to figure things out, get everything situated. That was kind of the historical context for how this came to be.
Got it. That makes sense. And I have personally seen in our office how, especially either for a surviving spouse, whether it's a male or a female, doesn't matter, how the benefits of year support and what our team does for the creditors has helped them out so much.
Oh,
where
absolutely.
I've seen situations with $50,000 in medical bills, $60,000 in credit card bills, and they were all pretty much eliminated, or in many situations they were. So it's a huge benefit for surviving spouses to know about that.
Absolutely. It's very powerful. The stories you're talking about, I've seen them as well.
Yeah.
We're able to eliminate huge amounts of creditor bills with this tool.
Yeah.
It's a marvelous tool for that purpose.
Yeah.
I think the key, again, is not waiting.
Yeah.
It's jumping on the situation. And let me talk a little bit about the timing, why I think that's so important.
Yeah.
I think the timing of this is important because in an ideal scenario, we don't just want to file the year support. And the reason why is because when we file it, we have to list all assets we want, and we have to list all creditors and other interested parties. If we fail to list a creditor or interested party and notify the court of them, then that party is not bound by the year support, meaning it has no effect on them. Well, that's not good. It means they jump in front of the year support. So what we typically want to do is make sure we have time to identify all of those creditors. How do we do that? Well, we want to look at the mail. We want to look at past records. We want to begin the estate process. We want to go ahead and open the estate and run our debtor-creditor ad to cause creditors to have to file a claim.
Yeah.
That allows us, between each of those things and pulling credit and all that kind of stuff, which we can't pull credit until after we have the estate opened.
Somebody appointed.
We have to have somebody appointed to legally do that.
Yeah.
And so that is what allows us to develop a solid list of creditors, feel really good about it, so that when we file for year support, we know we got them all. And so when we look at the timing of that, I don't want folks to delay because that takes time. We've only got 2 years on our year support petition anyways.
Yeah.
And so we've had clients come to us where we've only got 2, 3, 4 months to get your support filed.
Yeah.
That's not enough time to do that work, to get the estate open and then run a creditor's ad. I mean, running the creditor's ad takes a month, and then the creditors have 3 months to respond. Well, that's 4 months.
Yeah.
So if we have less than that time, we're going to do the best we can.
Yeah.
We're going to do as much of the investigation as we can, and we're going to file our petition. But I'm not feeling as secure about it, right, or as good about it as I would if I had the time to go through the typical process that we know works, that gets it done well, that we're not going to have some random creditor pop up and they're not on the list and now we have to pay it.
Yeah. Yep.
So it does much better for the client to move early because we're able to get a much better result for the client. And at the end of the day, all of our processes, everything we do in the office, everything our lawyers do and paralegals do is designed for how can we get the best result for this client based on the facts they're bringing us.
Yeah, that makes sense. So I have a more rare situation, but we do see it from time to time. When we talk about year support, we're talking about legal marriages. So when I say that because of there was such a thing as common law marriage in Georgia in the past. And again, we don't see it too often anymore, but there have been clients come to us that they say they had a common law marriage.
Yeah.
How does that play into this if that's someone who feels like they may have had a common law marriage?
Ooh, that's a good question. Yeah, marriage is a marriage. So if we can prove the marriage, we have a marriage and we have year support. So then we look at how do we prove common law marriage? And in Georgia, common law marriage stopped in 1996. I believe the relationship had to begin in or before 1996.
Okay.
There's a number of requirements for common law marriage. Did you hold yourself out? Did you consummate the marriage? Like all of those kind of requirements. So we have to prove those requirements because we're not going to have the typical marriage certificate that you would normally have to prove the existence of a marriage.
Yeah.
But if we can prove it, then we're entitled to year support.
Yeah.
Now, what's the downside? We're in a dispute. We have the stepkids over here that are not too keen on this year support thing. So they can now challenge the existence of the marriage. And if they win there, they've won the year support battle.
Yeah.
If they lose there, we file our petition for year support, right? Because we won and showed the marriage. They get another chance to attack on the year support directly. So it's just another process that we have to go through that gives our opponent an opportunity to attack what we're trying to do.
That makes sense.
Some interesting things, just as a bit of trivia, since you asked,
Yeah.
we've actually weird things with common law marriage because, every states that have had or currently have common law marriage have their own rules about it. Mm-hmm. Well, because of the full faith and credit provision in the U.S. Constitution, if we can prove the common law marriage in any state, it has to be accepted in this state. So we've had circumstances where we couldn't quite get it in Georgia.
Yeah.
But for example, maybe the couple had lived in another state. I'm trying to remember one. I think it was one of the Carolinas in this case. They had lived in one of those states for a period of time.
Okay.
And we were able to go back and look at that state's common law marriage rules, find out, oh, wow, look, we can check all the boxes there. We couldn't get it done in Georgia, but we could get it done under that state, prove the existence of the marriage in that state at that time, show the continuity of the relationship in the marriage to the present day and to the date of death, and then our court in Georgia accepted the existence of the marriage because it was a valid marriage under a foreign state's laws, even though it would not have qualified as a common law marriage in Georgia.
Look at that strategy. Oh my gosh. Wow. So it was still upheld here because it was there.
And that allowed us to file the year support and push the year support through and make a difference in that surviving spouse's life.
That is so interesting. Okay. Yeah, as long as I've been doing this, I think year support is the thing that sticks out to me the most as being, again, the number one advantage for a surviving spouse or a minor child when it comes to estate administration. It can be a disadvantage, unfortunately, for the stepkids of the stepmom. I mean, the deceased children, because they could potentially inherit less depending on how it goes. But when there's not a will, but with a surviving spouse, again, it's been a huge benefit for them from what I've seen.
Yeah, I think that's the nature of law.
Yeah,
that's and law is just the arrangements and agreements that we have as a society for how things work.
Yeah.
Whenever there's an advantage created for one party, there is always a corresponding disadvantage for someone else.
Makes sense. It does.
And your support creates an advantage for a surviving spouse, and it creates an equal disadvantage for creditors and for other heirs of the estate. That are not the surviving spouse.
Oh. Does it change if there's a will for the year support? Does that change it?
That's a great question. Yes and no. So let me explain. Because generally speaking, no. Because remember, our standard process is identify and pay creditors, then make distributions under state law or the will.
Yeah.
Okay. Well, year support just adds the surviving spouse as a creditor. So then that surviving spouse gets whatever distribution, payment, cash, whatnot under the year support.
Yeah.
Pay the rest of the creditors. Then we go to the will and we say, what does the will say? And we do whatever the will says with whatever assets are left.
Yeah.
There is an exception to that, though. A will, one of the other things a will can do is it can force a year support election. And what that means is the person that are deceased can put in the will a statement that essentially says, what I have written in my will for my spouse is in lieu of year support. And that's an enforceable statement. What that means is it forces the spouse to make a choice. They can file year support and go for year support, but if they do, they forfeit anything the will gives them.
Oh, wow.
Or they cannot go with year support and take whatever they get under the will. And so what do you do, right? It
Yeah.
depends. Again, we're back to the analysis of, okay, let's see under scenario A, if we don't file years support, these are where we think the creditors are.
Yeah.
This is what the spouse is going to get under the will. If we do file for years support, we think these family members will object or won't object. We have these creditors, we think they will object, won't object.
Yeah.
If someone does object, all right, if we look at the math, we think this amount of money was the starting point, or this is what was lost as a result of the death. They didn't receive a ton of life insurance. There aren't a lot of other assets. So you're looking at those kind of calculations to figure out, should I even file the years support petition or not?
Yeah.
And on that type of an election, much like the no contest clause we've discussed in the past, when you file the petition, you've made your choice.
Yep.
Even if you later dismiss the years support petition, you've still made your choice under that election in the will. And so it's a big decision. It's a big decision that requires consideration and a thoughtful analysis and some conversations with the client, the legal team, to make sure we're making the right decision for that case and that client.
Exactly. That makes a lot of sense. So, as you know, we like to ask our social media users to send in comments and questions in the comment section. So we have one here for you. In this situation, the person who commented said that his father passed away 5 years ago. Commenter and sibling are the only children of their father, so 2 kids. He was married. Stepmom is not the mother of him or his sibling. When the father passed away, stepmom had asked him to sign papers to let her handle the estate and then stop communicating with them altogether, which we hear often, unfortunately. What can they do? What should they do?
Great question. I really enjoy taking questions from folks. I love real scenarios.
Yeah.
It's a hard situation. And it's one of those, you heard me say before, when you're in a situation like this, one of the things you absolutely do not want to do is delay. And another thing you absolutely don't want to do is just sign paperwork somebody puts in front of you. You've got to follow your gut. And so here, there's a ton of red flags for me. The number one red flag is stopping communication. That's always a red flag for me. If we've got a client that comes in and you're in a situation and you're asking questions and the other side just stops answering them or becomes evasive, that's always a red flag. You've got to follow your gut on that red flag.
Yeah.
Don't let it keep going. And so here, if what I suspect, and I'm guessing, what I suspect she had him sign was papers to either, if there was a will, you didn't say if there was a will or not, but if there was a will, it was probably some paperwork to say, I agree with the will and I'm not going to object to it. If there was not a will, it was probably paperwork that says, I agree, you can be in charge of the estate.
Okay.
That's what I suspect it was. It could also have been, since it is a surviving spouse, it could have been a year support consent. You can have consents to year support where if all of the interested parties agree to it, it does accelerate the process. So that could have been a year support consent. And so I would say in this situation, the first thing I would do is I would pull all of the filings from the court. Okay. I want to know exactly what he signed.
Yeah.
And that should be on file with the court. I also want to know everything that the stepmother has filed. Did she file year support? Was she opening the estate with a will or without a will? What did the court do? I want to see the court's orders.
Yeah.
Did the court appoint her as the administrator or executor? Did the court require inventories or annual returns? Did the court require a bond? Did the court give her expanded or limited powers? Okay. Unfortunately, because she asked him to sign something, I would suspect that very likely she has expanded powers, there's no bond, and there's no inventory. Because typically when you're asked to sign something like that, those are waivers you're going to get as a part of that paperwork almost automatically. Not always, but it's a part of the typical paperwork in that respect. And so I would move very quickly, and I would begin that investigation to see what's in the court files. I would also want to reach out to the stepmom, probably by phone at first, but if that doesn't get anywhere, then it would be a letter, a very formal, somewhat demanding letter of, we need this information, we need to know what's going on.
Yeah.
That's where I would start. What I'm looking for in that is I am looking to see if everything is done right. So my first goal here would be to get truth for the client.
Okay.
I want to get to the truth, and I want to get to the bottom of what's really going on.
Yeah.
If, for example, we find, okay, there is a will, she filed a petition for will, we look at the will, the client looks at the will, and the will says I give everything to her.
Mm-hmm.
And the client says, gosh, that's Dad's signature. I mean, I've seen his signature 1,000 times. That looks just like it. Okay. And we look at the will, and like, there's no technical deficiencies with the will. Maybe we and the client agree to investigate a little bit. We call the witnesses. We interview the witnesses to the will. If there's a drafting attorney, we interview the drafting attorney. If everything comes back like, yeah, the signing ceremony was good, we look into the circumstances surrounding the passing of his father, and it's like he wasn't on pain meds. The will was written 5 years ago. It wasn't like a deathbed will. We're really not getting any traction. Maybe we don't do anything.
Yeah.
Maybe the outcome of that is we tell the client, here is the evidence we found. This is what we think the evidence shows. We can't find anything that looks like there's anything wrong going on here. Now, what she's done is controlling. What she's done was manipulative. What she's done morally is wrong, and it's not the right way to treat your family, but legally we don't really have anything to go on. And if that's the case, we tell the client that. And that's always a hard conversation, but my opinion and what we teach and preach at the office is you have that kind of hard conversation because you'd rather have a hard conversation with a client they're not going to like now than going down that road and getting thousands and thousands of dollars down that road and then having the hard conversation with the client later, because that's where it's going.
Yeah.
Now, alternatively, maybe we pull the court files and we take a look at the will and we find out that doesn't look right. This will was written, 2 weeks before he died. The client's got another will that was 5 years old. Everything changed in the will 2 weeks ago. He was on heavy pain meds. It was something that you can tell was just printed off of the internet. Doesn't really look like it was done in a very valid way. Yeah. Then we've got some things we can start challenging, and we advise the client of that. Yeah. But the key is the first part is an investigation. And from the client side, what I would say is you have to be afraid. You need not be afraid to rock the boat. That's some of the best advice I can give. I mean, we always counsel clients because doing something does rock the boat. It is going to make, it is going to hurt some feelings sometimes. And we want to be careful with that. We always want to be careful with that. But if we're in a situation where we have someone that is trying to take advantage of a situation, unfortunately, they're counting on you not to rock the boat. And so you have to be willing to do that, to do the investigation, to set things right. Yeah. And that doesn't mean we have to come out, guns blazing and making accusations. But there's nothing wrong with sending a letter saying, I need the following information. I just need to verify for my client that everything's being done right. Yeah. I'm sure you're doing everything right, but, we need to see it. We need to see the evidence so that we can tell our client that everything is being done right.
It would give us some peace in the situation to know what that is.
And that's a valid request. Yeah. And if the person sends it over and everything's on the up and up, great. But what typically happens in that situation is you get no response or you get a whole lot of excuses. Yeah. And in that case, you've got to be willing to take the next step, which is typically filing something in court to require that this information be produced, and that's really where you can get to the heart of the matter. And to
add on to what you just said, it's really interesting. You said you have to be willing to kind of rock the boat to get this information. What I've told our potential clients and on consultations before, because they'll say, I don't know, I don't want to make her mad at me or anything. Yeah. But then when I'm asking them questions, they'll say, well, she has an attorney and she's doing this, that, and the other. The way my viewpoint is, and you can tell me if you think it's incorrect, but I see it as she already has her attorney. She already has someone looking out for her interests. And I think there's a common misconception that the heirs sometimes feel like that's everyone's attorney. It's the
Yeah.
estate's attorney. But really getting an attorney to help them investigate this isn't necessarily even trying to rock the boat. This person already has their help, their interest, protected. It's to level that playing field to say, now let's make sure your interests are protected as well, not just the person who has representation on the other side. Would you agree with that?
I would. And let me talk about the misconception. That's great.
Yeah.
It's great you brought that up because as attorneys, we have ethical rules we have to follow. Mm-hmm. And one of those rules is our duty to our client. So we have a duty to look out for the interests of our client to the exclusion of everybody else, right? That's what, when you think of an attorney, that's what you think of.
Yeah.
And so we also have a duty of confidentiality, meaning that if a client tells us something, we are going to keep that information confidential unless we need to use it to prosecute the client's case. Mm-hmm. And so the client's secrets are safe with us.
Yeah.
Well, when the executor or administrator of the estate hires an attorney to represent them as administrator or executor, that attorney does not represent the estate. That attorney represents the executor or the administrator and is advising them in their capacity as executor or administrator. But that attorney does not have any duties at all to any of the heirs or the beneficiaries of the estate. Mm-hmm. So if that administrator or executor confides in the attorney and says and tells them information, that attorney is not going to share that. That attorney is not only not going to share the information, they're prohibited from sharing the information. Mm-hmm. Now, that attorney should advise their client, the executor administrator, that Mr. Executor or Miss Administrator, you have duties to the heirs and the beneficiaries and the creditors of the estate. And here are what your duties are. Mm-hmm. The executor or administrator can take that advice, reject that advice. They can completely ignore that advice, go make a bunch of mistakes, come back to their lawyer and say, oh my gosh, I don't know what to do. I'm in trouble.
Yeah.
The lawyer's job is not to then say, you know what? Yes, you are. You've done all these bad things wrong, and now I'm going to have to go to the court and go to the other heirs and tell them all the bad things you've done wrong. No, the lawyer's job is to say, okay, let's see what we can do here. Tell me everything. Mm-hmm. Tell me everything. Okay. All right, well, let's look at this. If we look at this in a different light, I don't think it's that bad. I think we could shape this in that way. Mm-hmm. And I think this over here, let me ask you a question. When you did that, you believed that you were doing it in this way, didn't you? The client says, yeah, I absolutely did. That's what I thought. Mm-hmm. That lawyer's job is to help the executor or the administrator stay out of trouble and get out of trouble. Mm. So the heir or the beneficiary has to have their own representation if there is conflict or if there is any kind of suspicion of the executor or administrator not doing their job, because that attorney does not represent them in any way.
Yeah. That's a great thing to explain to people, because they don't, and that it makes sense why you would think that attorney is representing the whole estate. They're an attorney. They need to do what's right for everyone. But as you said in your example there, they're really just looking out for that executor's interest to make sure that they can stay out of trouble if possible.
Absolutely.
Yeah.
And it is their job. It's their duty. It's not that the lawyer is doing anything bad. The lawyer is doing the job we're called upon to do. Yeah. If a client hires us, it is our job to work for that client to the best of our ability. Mm-hmm. And that's what they're doing.
Exactly.
And so the executor administrator can rely on their lawyer to do the best, to work for their interests to the best of their ability. Yeah. Meanwhile, when the heir or beneficiary hires an attorney, they can rely on their attorney to work for their interests to the best of their ability.
Exactly. Going back to the surviving spouse situation that we've been talking about here, we had one that was really interesting recently that was regarding a prenuptial agreement. And that one was really confusing, because how do prenuptial agreements come into play when it comes to estates? And for a lot of people who don't know what a prenuptial agreement, what is it? Can you explain that a little bit?
That's a good question. So prenuptial agreements, and I'm not a divorce guy, so I might mess this up. I know prenuptial agreements as we deal with them.
Yeah.
A prenuptial agreement is an agreement that folks can enter into before they get married. Mm-hmm. And a lot of times it deals with what happens if we get divorced. It can also deal with what happens if one of us dies. That's the part we get involved with,
Yeah.
right? We're not so concerned of what happens if y'all get divorced, but we are concerned of what happens when somebody passes away.
Yeah.
So you've got a prenup that is entered into before the marriage begins, and then you have a post-nuptial agreement sometimes, which is made during the marriage. They both are complicated. They have their requirements for how to do it correctly and, to be valid and whatnot. But if they're done correctly, they are valid against the estate and in the estate and in the probate context.
Yeah. So we had the situation I'm talking about. One of our potential clients recently had a situation where their father did pass away. He had promised her specific jewelry and items that would go to our potential client. But then the surviving spouse of the deceased pulled out that was supposed to be in the prenuptial agreement that they were getting the jewelry. But then the surviving spouse was saying, no, it's all mine. Everything in this house is my property. It's marital property. You're not getting any of it. What can she do in those type of situations if the prenup says, well, it's supposed to be split this way, but then the surviving spouse is saying, no, it's not going to be?
So in that situation, I would really look to the prenup because if they defined property like that specifically in the prenuptial agreement, I would look there. Now, the interesting thing about it, and I just don't know this without doing some research, is prenuptial agreements affect the rights between the spouses. But in your example, you have what sounds like a child, a daughter.
Yes, you got it.
And the prenuptial agreement is saying that this property is going to go to the daughter should I die or should we get divorced.
Yeah.
I would imagine, and again, I'm speculating here because I haven't done the research on this, but I would imagine that that's probably enforceable. And my argument would be that it's enforceable because the other party claiming the right is the other spouse that was a party to the prenuptial agreement. And so that spouse gave up any right that she had to that property when she signed the prenuptial agreement and agreed that it would go to the daughter. So it sounds to me like the daughter is an intended third-party beneficiary, and that's the argument that I would want to make for that particular situation based on what you told me so far. I don't know if it would work or not. I'd have to do the research, but that's what I would want to say, and I would want to say that daughter is probably in a pretty good position. I think. That said, I think if I change your facts a little bit, and I say it was, you have daughter 1 and daughter 2.
Okay.
And this is daughter 2 saying, no, I want this. I think that changes it because daughter 2 isn't a spouse and wasn't a party to the prenuptial agreement.
Okay.
And I think that, I don't know, that would be interesting to me. But I think because the other party that's claiming the right is the spouse that signed the prenup, I think that we're pretty good there.
I love that. It's really interesting. A lot to consider with those types of situations. Cool. We went over a lot today again.
Yeah.
With
Fun
all this,
topics.
Yeah. Really interesting. A lot more we could dive into. But for our listeners out there, please comment more questions. We love the questions. Those are one of our favorite times of this podcast is to answer the questions you guys have because those are what we really want to address moving forward. Of course, reach out to our office at any time if you have a specific situation that you need some help with. I think that's it for today, but thank you guys so much for listening to Probate Matters. Erik, thank you.
Yeah, thank you, Jenny. And remember, like and